Hello, so today's question is, should you put assets in your child's name? So today you will learn why the answer to this question is almost always no, the problems that this can cause, and some better alternatives to this. I am attorney Robert Pecori. I've been an estate planning and elder law lawyer now for 30 years in my family's firm, Pecori Pecori. So this question is one that I get quite often, and again, the answer is almost universally no. Usually it's someone looking to save on inheritance tax, but as we'll discuss, it's generally just not worth it. There are two major problems to adding someone's name to your property or just gifting it to them: ownership and taxation. So first, with ownership, when, for example, you place your child's name on your house, or you gift your house to them, you deed it to them entirely, they now have an ownership interest, or indeed they own, quote unquote, your house. You're now subject, you may have the best kid in the world, but you're now subject to the trials and travails of your kid's life. If they get a divorce, they file bankruptcy, they have lawsuit issues, guess what? Quote unquote, your house is now at stake. I'll share a story with you. I had a long-term time client who wanted to gift her house to her daughter and son-in-law as they were moving in to take care of her. I explained to her why this was a bad idea. I also knew the son-in-law was a bad actor, so I refused to do this for this client. She got angry. She went to another attorney who made the deed for her. 6 months later, they moved mom into a nursing home and sold the house against her wishes, and there was nothing she could do, unfortunately. So the second reason, taxation. So when mom gifts her house to you, you get her tax basis in the property. So for example, let's say mom paid 25 grand for her house 40 years ago. It's now worth 300,000. If she transfers it to you, you have an asset for taxation purposes worth 25. So if and when you sell it for 300, you owe capital gains tax on the difference, or on 275. Capital gains tax is taxed at your level of income. The minimum income tax rates are 10 and 12%. If you instead inherited the house, in our example, you're subject to inheritance tax in PA at 4.5% on the full value. But when you run the math on both of these transactions, the inheritance tax is usually much less. Plus, you get a step up in basis when you inherit. So in our example, you'll pay inheritance tax on a $300,000 home, but then if you sell it for $300,000, no capital gains tax. The ownership issue alone is usually reason enough not to gift assets, but the taxation issue is usually just icing on the cake. I usually suggest a client simply keep what they have, but another safer alternative is to do some trust planning. If we use, for example, an asset protection trust, you can remain in control of your asset and still ensure that your kids will get it when you're gone. You'll also not have to worry about any issues in their lives affecting your property. Also, an asset protection trust can help you protect assets like your house from the devastating cost of nursing home care. For more information about this type of planning, please visit my website at pecorielderlaw.com, where I have a webinar about protecting your assets from nursing home costs. Or please watch some of my other videos. Thanks for tuning in today. Please hit the subscribe button if you enjoy our content, and if you have questions or comments, please leave them below. Thanks. Have a great day.